If your company uses workers from a staffing agency, here's a question worth asking. Are you really just their client, or are you also acting like an employer? Many business owners assume that if the staffing company hired the worker and issues the paychecks, the staffing company is solely responsible as the worker's employer. That's not always true. I'm Alex Rubin of Rubin Employment Law. In some situations, your business may be considered a joint employer along with the staffing agency. If that happens, you may have legal obligations of your own. But there isn't only one joint employer test that applies everywhere. Different laws view the relationship differently. Just to be clear, this video is for informational purposes only. It is not legal advice, and watching it does not create an attorney-client relationship. For legal guidance, please speak to an employment attorney in your state. Under the current National Labor Relations Board rule in effect in 2026, the focus for federal labor law purposes is whether your company exercises substantial direct and immediate control over such key terms as wages, hours, hiring, firing, discipline, supervision, and direction. Other laws, including wage and hour laws, anti-discrimination laws, leave laws, and safety laws, also may create responsibilities for both the staffing firm and the company client when they are both functioning as employers. So, what should business owners watch for? Ask yourself, who supervises the worker day to day? Who sets their schedule? Who gives them instructions? Who handles their performance problems? Who decides whether the worker stays or is let go? Who addresses any complaints from or about the worker? And who's responsible for safety training on site? If the answer to any of these questions is your company, then you should not assume the staffing agency is the only one with legal exposure. For example, the Occupational Safety and Health Administration, the federal agency that determines workplace safety and health standards, says that the staffing agency and the host employer are jointly responsible for maintaining a safe workplace for temporary workers. U.S. Equal Employment Opportunity Commission guidance also makes clear that staffing workers may be employees of the staffing firm, the company client, or both, and that both may be liable for discrimination or harassment. And under the Federal Family and Medical Leave Act, the primary employer, the staffing agency, and the secondary employer, the company client, have different responsibilities, even with temporary employee placements. The bottom line is this: using staffing agency workers can be a smart business tool, but it's not a legal shield. If your company is directing the work, controlling the conditions, or managing the worker in a meaningful way, you need to understand what responsibilities come with that role. Because by the time a complaint is filed, it's too late to figure out which entity should have handled the situation. If you have questions about whether or not your company is responsible for workers hired through a staffing company, call us at 973-787-8442, email us at legaladmin@alexrubinlaw.com, or visit us at alexrubinlaw.com/joint-employer.